Mr. Otti, before you resume, Lord Sumption has something he wants to put to you.
Have you been handed this Privy Council case? The reason I draw it to your attention is that it's at least arguably authority for the proposition that once it's established that a legislative provision is valid, it's not permissible to assert that a party has, in breach of some legal duty, caused it to become law. The relevant parts are particularly pages 222 to 223.
322 to 323.
322.
Sorry, 322 to 323, and it was adopted by the House of Lords in Pickin and British Railways Board in 1972. Don't respond to it straight away, but in due course I would welcome your submissions on the point.
I'm very grateful, Lord. And it is the point that is being put to us that this is analogous with the exercise we're seeking to engage in relation to the 1267 committee.
Well, it may be, is what I'm saying.
We will think further about that, my lord. An immediate response, if that is the possible analogy.
I don't want you to feel bound to give it an immediate response because it's come at you out of the blue.
Thank you, my lord.
I think it may well repay.
We'll certainly reflect
careful
on
examination.
it further. I'm grateful. Thank you. Can I then go to the third and fourth grounds of our appeal?
Yes.
What we call the standard of proof ground and the standard of review ground. The standard of proof ground first. It's addressed in the paragraphs that we've noted in our core propositions document, and it involves the three stages of argument set out in that document on page 2 at 1 to 3 under ground 3 in introducing the test of reasonable suspicion, because we say it was the United Kingdom's executive which introduced that test. The respondent was doing so without any statutory mandate, and we say on a proper application of the principle of legality, given the drastic consequences which followed, that was not legitimate. Secondly, and alternatively, we say that the decision by the United Kingdom executive as to which standard of proof to apply, namely balance of probabilities, reasonable belief, reasonable suspicion, being amongst the candidates, the United Kingdom at least had to act in a manner which was a necessary and proportionate response to the resolutions it was responding to. And it is not enough for that decision merely to have been within the range of Wednesbury reasonable responses. Thirdly, the introduction of such a standard of proof cannot, we say, be treated as necessary or proportionate as a response to the resolutions in issue, because they contained neither an implied nor an express requirement for the application of that low standard. Now, the first part of the first of those propositions, at least, is common ground. There was no relevant statutory authority for the application of a reasonable suspicion standard. The debate between the parties as to that first stage of the argument is what the implications of Ahmed are for that state of affairs. And the second and third stages of the argument are also, of course, both in issue. I'd like to go straight to Ahmed, if I could. You find that in bundle 1 behind tab 2. And the four propositions which we say can be derived from Ahmed,
yes,
which support our case, are those set out at paragraph 4 on page 3 of our core propositions document.
Oh, yes, thank you.
Namely, the principle of legality, we say, given its proper reach, operates generally as a prohibition on the misuse of power, and the courts will not countenance attempts by the executive to adversely affect the basic rights of the citizen without the clear authority of Parliament. Secondly, we say, notwithstanding the licensing regimes which may be in place, the effect of an individual's assets being frozen in response to a UN listing is very grave indeed, and that provides the critical context in which the court's review of this aspect of executive conduct has to be considered. Thirdly, the intended preventative nature of sanctions in this area cannot of itself be sufficient to render the adoption of a standard of proof as low as reasonable suspicion necessary to give effect to the strict requirements of any Security Council resolution. And thirdly, there are no relevant Security Council resolutions in the present context whose text render the adoption of such a standard necessary. So Ahmed itself, as I say, Volume 1, Tab 2, and Lord Hope's speech first, beginning at page 6110 of the report, MS 1300.
Thank you.
This is the leading speech, although I will refer to each of them. It's the leading speech because it was agreed with in its entirety by Lord Walker and Baroness Hale, and within the context of a separate speech by Lord Roger. And I'd like to emphasise a series of passages in it which we say are supportive of each of the four propositions that we've sought to summarise and identify. Paragraph 3 first. With the reference to the appellant, and at paragraph 4 by C to D to the impact of these designations. Paragraph 6 and the citation from Lord Bingham's observations about Liversidge and Anderson, which I started my submissions with this morning,
Yes.
and the fundamental role of the courts as guarantors of legality, and the reference in Lord Hope's speech after the quoted passage to the drastic and oppressive nature of the regime. And the last three lines of that paragraph are at the core of the way we put our case on this appeal. Paragraphs 17 to 22 contain the history of resolutions to that point, and Resolution 1373, which was the primary resolution in issue in Ahmed, is set out at paragraph 21.
Sure.
Paragraph 31 at the foot of the page, and then again paragraphs 38 to 39. Lord Hope comments on the kind of impact the measures have had upon the appellants in Ahmed, and uses the terms I started with this morning: very burdensome, remorseless, devastating, and oppressive. I note in passing, if I may, paragraph 34, where Lord Hope refers to, without indicating any disagreement as a matter of principle, refers to the Court of Appeal's finding as to the availability of a judicial review of the merits of a decision to support designation, which will be relevant to my fourth ground of appeal.
Where is that?
It's at the top of page 622 in paragraph 34, where the Court of Appeal's finding is recorded. Paragraph 47 refers to the section of the United Nations Act, which was, of course, at the core of Ahmed, and the concept of necessity. And paragraphs 55 onwards deal with the challenge to the terrorism order, one of the two orders challenged in those proceedings. Now, what was objected to in relation to the terrorism order was the introduction of a test of reasonable suspicion, which did not feature expressly in the underlying resolutions, and the question was whether, notwithstanding that, it could be said to be necessary or expedient to introduce that test, and so have an adequate legal foundation by virtue of Section 1 of the 1946 Act. Paragraph 58, Lord Hope held that it was not necessary to introduce a test of reasonable suspicion to reproduce what the relevant Security Council resolution required. And though he held in paragraph 58, just by letter C, that it may well have been expedient to introduce such a test, he said that so widening the scope of the order was no mere drafting exercise, given the devastating impact of the measures in question, and that a more fundamental question was raised, and this is the last 3 lines of that paragraph, whether the exercise of judgment in matters of this kind should be left exclusively, without parliamentary scrutiny, to the executive. He referred at paragraph 59 to the submission based upon evidence that a reasonable suspicion test had overall support from states and was reflected in the International Task Force guidance. I put down a marker here because the Task Force guidance is the same guidance that's relied upon by Mr. Swift on this appeal. We say it's telling it didn't lead to any finding of legality in Ahmed. Paragraphs 60 and 61 are the critical paragraphs of Lord Hope's judgment where he deals with the outcome on this question. And notwithstanding the fact that, as you've seen, he's held that it might well have been expedient to introduce a reasonable suspicion test, he holds that the matters he's referred
This
to...
is paragraph,
60 and paragraph 58 is the may well,
this is 60, sorry.
and this is now I'm on to 60 and
Sorry.
61,
Thank you.
where he holds that the matters that have been identified are not sufficient to meet the basic objection, as he described it, to the introduction of the test.
What are you relying on this for? On the construction of the United Nations scheme, or what?
I rely upon it for a broader concept of the principle of legality than one which merely informs the construction of legislation. And
But you're relying on it to criticise the decision of the UK representative to agree to listing.
No, I'm sorry. In this context, I'm relying upon it to criticise and challenge the decision of the United Kingdom internally to apply a standard of proof of reasonable suspicion when internally deciding or reaching its own view on whether the criteria were met. So this is a purely domestic focused challenge, because what happened in this case, we say, is the relevant sequence is the UN resolutions contain no statement requiring a particular standard of proof. An individual is proposed for designation, and on the Secretary of State's approach, it was then the Secretary of State's decision and exercise in that 6 months while the process was on hold and the designation was on hold, to determine for himself whether, in his view, my client and others, but my client for these purposes, met the criteria for listing. And he did so by applying domestically a standard of reasonable suspicion.
Was he doing it domestically? I mean, the question what standard is required to justify a listing decision by the 1267 committee is going to be a question of international law. It's going to depend on the terms of the resolution and the practice of the organs of the United Nations, isn't it? So if those sources justify what you call a reasonable suspicion test, would it be unlawful for the Secretary of State to apply that test in deciding how to make his own decision as a member of the committee?
If those sources required the application of a
No, let's suppose they permitted them. Let's suppose that was the ordinary basis on which the committee as such was entitled to act.
If they didn't require it, but they merely permitted it.
Well, they required, I mean, you can't have something which says we'll apply different tests. Presumably, the United Nations scheme must be subject to some test which members of the Security Council are then, in the ordinary course, expected to apply. The United Nations can't be saying, well, you come along and apply whatever test you like. The scheme only operates on the basis that there will be moves towards a consensus on some common basis.
But the premise for argument in and indeed the view of Lord Hope was that the resolutions themselves had left it open to individual member states to decide for themselves which particular standard of proof to adopt. But they hadn't.
Where does he say that? I thought he said he had overall support among states at 1320F.
It's beginning of paragraph 58 that I was thinking of, where he's dealing with the resolution in issue there. The standard of proof is not addressed. The question how persons falling within the ambit of the decision are to be identified is left to the member states.
Well, that's the member states collectively, isn't it? It's not saying each of them has got to decide in accordance with his own domestic law.
It may be Lord Hope isn't actually in his possession of as full information as we are, although he does refer at F to the some evidence.
He refers at F to the task force endorsement of.
I mean, we have to. This case goes to, on this aspect, a completely different point, the one that's in front of us, doesn't it? It goes to the varies of the Order in Council, and it was said, effectively, whatever the standard required at the UN level, even if it was reasonable suspicion, this can't have been something which was domestically open to be done under the United Nations Act, because the United Nations Act was drafted in a different era with quite different things in mind. And it particularly can't be done if the UN test is reasonable suspicion. Actually, he said it particularly can't be done here because he thought that the domestic test adopted was reasonable suspicion. But that's not our question. Our question here, we do have to decide what the UN requires. And as Lord Sumption says, if the UN expects people to apply a test of reasonable suspicion, you can hardly blame an individual diplomat for applying that test.
No, in my case is that the UN resolutions did not require that test.
Yeah.
I mean, the critical point there, or one of the critical points, is presumably whether reasonable suspicion is substantially the same as reasonable basis, which is the expression that Mr. Swift, I think, relies upon as justifying the approach that was actually taken.
Well, there are two, we'll come to the detail of it in a moment. Mr. Swift relies to an interpretive note, to a special recommendation from this task force, which, in a context which we disagree about, contemplates both reasonable belief and reasonable suspicion. That's the beginning and the end of it in terms of what was specifically contemplated. In terms of reasonable basis for a decision that criteria are met, or reasonable and credible basis, that's a formulation which comes later.
It comes from the ombudsperson.
Comes from the ombudsperson, and so we say isn't available to test the legality of what's happening in 2005.
I mean, I think the argument is, rightly or wrongly, that although it comes from the ombudsperson some years later, its acceptance by the committee indicates that this corresponded to the practice.
The argument is it's akin to reasonable suspicion, and so there can't be any complaint about it. And the answer to that is that the ombudsperson has said in terms that her test is not to be equated with any test applied at the domestic level in municipal jurisdictions. That's how we put our response to that. But to go back to the original question in this sequence of exchanges raised by my Lord Mance, what are we relying upon this for in the context of this case? We are relying upon what we say are the critical findings in paragraphs, or the critical reasoning in paragraphs 60 and 61, which we say preclude any attempt by the executive to adversely affect the basic rights of the citizen without the clear authority of Parliament. And we say that the principle of legality properly understood and articulated here has that reach, and demonstrably has that reach, when Lord Hope is accepting in paragraph 58 that, as a matter of strict construction, introduction of a test of this kind could be characterised as expedient, and so within the wording used in the 1946 Act. But he's nevertheless identifying a more fundamental objection, that if a step taken by the executive is going to have an effect of this kind, then it has to have, consistent with the principle of legality, the cloak of express sanction from Parliament.
Right.
The reference in Lord Hope to Entick and Carrington from my Lord Commonwealth's note is paragraph 75 to 76, where he's dealing with the Al-Qaeda order, and he summarises the principle in Entick and Carrington by letter F as a fundamental right and a fundamental constitutional principle. The right to peaceful enjoyment of property, which could only be interfered with by clear legislative words. And then in paragraph 76, he acknowledges that even the 1946 Act, which was relied upon as providing the basis of legality in Ahmed, must be taken as contemplating at least some level of interference with ordinary civil rights because of reference to provisions for apprehension, trial and punishment. But he then concludes there must come a point when the intrusion upon the right to enjoyment of one's property is so great, so overwhelming and so timeless that the absence of any effective means of challenging it means that this can only be brought about under the express authority of Parliament. So that's Lord Hope. Lord Phillips next, if I may, paragraph 129 onwards, he explains why, in his view, the terrorism order under challenge went further than the underlying resolution in issue required, and so could not be characterised as either necessary or expedient within the meaning of the Act. At 136, he expresses the view that the natural response to the resolution would have been to freeze the assets of those convicted. At 137, importantly for this purpose perhaps, he explains that the resolution nowhere required freezing of assets of those merely suspected of terrorism, and commented that even adopting a test of reasonable suspicion would almost inevitably catch the innocent in a regime with what he called dire consequences. At 138, he rejected the notion that the word expedient could be given what he called the extravagant scope of enmeshing in asset freezing those who had done nothing wrong. At 139 to 143, he made it clear that he'd looked for guidance as to the interpretation of Resolution 1373 in the parallel resolutions, including the one with which this appeal before the court today is particularly concerned, namely 1617 of 2005. But he'd found nothing there to support the notion that asset freezing should occur on the basis of suspicion. He expressed the preliminary view at 142 to 143 that the statements that the instruments contained to the effect that a criminal charge or conviction was not necessary and that the measures were preventative in nature, same kind of wording relied upon here, opened the door to the suggestion that the freezing order should be imposed where reasonable grounds for belief existed, but even there considered it was manifestly preferable for any such measure to be imposed by primary legislation. Lord Roger, next, he did not feel able to conclude that a reasonable suspicion test was not expedient, paragraph 173, by letter F. But he acknowledged, again, in a passage going to the significance of adopting a reasonable suspicion test, which we are challenging here, he acknowledged at 174 that adopting that kind of test would mean that sooner or later someone would be designated who had done nothing wrong. That was inevitable. And in the light of that consideration, he agreed with Lord Hope's analysis that to confer on the executive such significant powers to affect directly very basic domestic law rights could not be done without express parliamentary deliberation and approval. Now, all of these passages going to what we say is the true foundation for the principle of legality, which we acknowledge has historically been deployed principally as a tool of statutory interpretation, which we say is the true foundation of it, support us both on ground 2, the Entick and Carrington ground, and on ground 3, reasonable suspicion. Of course, with ground 3, we don't have the extra layers of complication that I've been seeking to address, dealing with the significance or otherwise of other potential decision makers on the scene, whether it be the committee or the European Union. Lord Brown at 192 emphasised, as had each of the other judgments, the draconian and paralysing nature of the regime. And at 193 said that these were powerful reasons for questioning the legitimacy of introducing such restrictive measures. And he held at 197 that the introduction of a test of reasonable suspicion went well beyond the strict requirements of Resolution 1373. My Lord Mance's judgment next, and the history, this is the only judgment we have where the history of targeted resolutions is set out, the matter that was raised this morning, and it's in Lord Mance's judgment at 215 to 216, where it's made clear that the targeting of specific individuals began in the early 1990s in relation to those exercising de facto government power in relation to Haiti and Angola. Right. But then 216, the observation that these resolutions can be said to go further because they're directed not only at particular non-state actors, but individuals associated with non-state actors. And it's, we say, important to emphasise that history because it again meets the quite understandable, but we say non-determinative concern which arises in response to the exercise we say the courts here should properly undertake. This is an extremely unusual United Nations regime. The 1267 Committee is purporting to do something which had not previously been within the remit, or within the area of operation at least, of the United Nations. The specific identification and targeting of individuals in this jurisdiction for restrictive measures. My Lord Mance identified at 220 the essential question before the court in Ahmed as he saw it, whether the terrorism order could be regarded as making such provisions was necessary or expedient so as to fall within Section 1 of the 1946 Act. At 225 to 226, Your Lordship identified other resolutions where the Security Council had specifically identified a standard of proof to be applied and contrasted that with the resolution in issue in Ahmed. At 227, the preventative nature of the sanctions is considered and acknowledged, but it said that those provisions would more naturally be read as suggesting application of a civil standard of balance of probabilities, rather than as mandating a test of reasonable suspicion. The Lordship acknowledged at 228 that expediency was wider than necessity, but at 230 found that there was an objective limit to the breadth that could be given even to that term. And if conduct by the executive went as far as to change the essential nature and target of the freezing order, that would be to go too far, particularly given what was described as the major inroad into rights. So, back to our core propositions, which we say those passages support. They're at paragraph 4, as I say, of the document we handed in yesterday. I've made my submissions as to the breadth of the principle of legality, and that really is, we say, the fundamental objection that Lord Hope, with the leading speech, identified at 60 to 61. The licensing regimes which are prayed in aid against me here as somehow mitigating the draconian impact of the measures in question were the same licensing regimes as in play and considered in Ahmed. The preventative nature of the sanctions was expressly considered in Ahmed and held not to justify a reasonable suspicion test. And none of the judgments found that application of a reasonable suspicion test was necessary. There was a difference of view as to whether it was expedient, but none of them found it to be necessary. And so if we're right that the proper test for the adoption, the legality of adopting a reasonable suspicion standard is one of necessity and proportionality in response to the resolutions, rather than, as the courts below found, one merely of Wednesbury rationality, then we say we are home on this ground of appeal, because it cannot be said that the adoption of reasonable suspicion is necessary on the face of the resolutions. And that takes me then to that the second stage of our argument under this ground, namely what is the appropriate test to apply to the United Kingdom's decision to use a standard of reasonable suspicion. And as I say, we say that the Court of Appeal, which appeared to proceed on the basis of a test of rationality, got it wrong and adopted an approach which was inconsistent with the approach indicated as appropriate by this court in Kennedy and Pham. Now, Kennedy and Pham are at the heart of our fourth ground of appeal on the question of standard of review of criteria and allegations of past conduct, but they also are of direct relevance here. If I can go, if I may, to Kennedy first, which is at tab 11 of Bundle 2. Of course, involved a very different context, that of disclosure of information relating to inquiries. But what is important for our purpose, we say, are the observations particularly of Lord Mance and Lord Toulson as to the flexibility of the remedy of judicial review according to its context, and perhaps particularly given the very unusual nature of the terrain this case covers, the observations of Lord Toulson as to the ability of the common law to develop to meet the challenges posed by new exercises of state power.
Turn it down.
So,
Glad you found that. I thought it was just me.
Kennedy and Lord Mance's judgment. First, we rely particularly on the passages at 51, 52, and 54.
51, 52, and 54.
51, 52, and 54.
Yep.
And in 51, beginning by letter G. The recognition in 52 of the evolution of common law.
And 54, yeah.
And 54, the recognition that in appropriate cases, judicial review is apt to cover issues of fact as well as of law. And in 54 also, between E and F, the advantage of the terminology of proportionality, with its structured attention to factors such as suitability and necessity, is identified. And the conclusion is expressed that there seemed no reason why such factors should not be relevant in judicial review, even outside the context of the Convention and European Union law. Now, Lord Mance's judgment is agreed with by Lord Newburger and Lord Clark, and also by Lord Toulson and Lord Sumption. And from Lord Toulson's judgment, we get the additional point that I've just mentioned at paragraph 133, and the unsurprising, as he saw it, equation of the result arrived at via common law principles and via Article 10. And just below letter G, the recognition that the growth of the state has presented the courts with new challenges to which they have responded by the process of gradual adoption and development of the common law. We rely upon here the use of the targeted measures flowing from the 1267 Committee's designations is a paradigm example of such an evolution or growth in powers claimed by the state. FAM then is to similar effect. It's at tab 14 of bundle 3.
Yes.
And the context in FAM is to some extent closer to the present case because it involved a challenge to executive conduct referable to the threat of international terrorism.
Yes.
In that case, the withdrawal of the citizenship of an individual assessed to have undergone terrorist training. And the case failed because the premise for it, that Mr. Pham had lost his Vietnamese nationality at the time the United Kingdom withdrew his British nationality, was held to be a bad premise. But the observations of the court as to the standard of review appropriate in a context touching upon fundamental common law rights in the judicial review framework are, we say, of relevance. And for these purposes, we rely upon observations from each of Lord Commonwealth, Lord Mance, Lord Sumption and Lord Reid. Lord Commonwealth first at paragraph 60, citing the majority view in Kennedy that judicial review was to be treated as a flexible remedy where important rights were at stake and would no longer insist on a rigid test of irrationality. Paragraph 94, Lord Mance referring to Kennedy and to the observations there made as having commanded the approval of the majority. Paragraph 105, my Lord Sumption, describing the stumbling of the English courts towards a concept similar to that of proportionality, and the solution adopted of incorporating at common law significant elements of the principle. At 107, my Lord Sumption recognised that differences between common law review and convention review might, depending on the context, be more or less significant, depending upon the significance of the right interfered with, the degree of interference involved, and the competence of the court to consider the matter. Now, in our case, we say, in a nutshell, that the stumbling should now end and there should be a clear identification and recognition of this as being the appropriate test to apply in a context such as the present. There is a fundamental constitutional common law right interfered with. The degree of interference is profound, devastating, oppressive, and so forth. And the competence of the courts to consider the matter, in this context, whether the resolutions required adoption of a reasonable suspicion test, and under ground 4, whether past allegations of past factual conduct are made out, is manifest. So each of the three touchstones my Lord has identified there, we say support the adoption of a stringent proportionality analysis. Yeah. Paragraph 109, my Lord Sumption emphasised that the common law no longer insisted on the single uniform standard of rationality review. And to similar effect, Lord Reed's speech, if I can just give the references, it's paragraphs 114, 115, 118, 119. Now, where then does that leave us on this ground of appeal? The Appellant submits that where the executive has acted in a manner which has an impact on fundamental rights of the gravity with which this appeal is concerned, it must show that the measure is proportionate. And that in turn involves showing that it is objectively necessary as a response to the resolutions which it is responding to. And we say, and this is the third stage of the argument, the respondent cannot do that. Now, the references to our case and the resolutions we rely upon are at 3 Little Roman 6 of our note of last week, the 11th of November note.
Yeah.
But the Secretary of State makes 2 points in contending that the adoption of the reasonable suspicion test was a necessary response to the resolutions in issue. He says, firstly, there was implicit authorization for the adoption of such a standard because of the preventative nature of the sanctions regime. And he says, secondly, that paragraph 7 of Resolution 1617 contains express encouragement and endorsement of the adoption of such a standard through its reference to the Financial Action Task Force special recommendations, which were handed up this morning and which I'll go to. Now, taking each of those in turn, the first, the preventative nature point, is not only an argument that was run and failed in Ahmed, it's, we say, a complete non sequitur to say that because a measure is preventative in nature, it necessarily requires adoption of a reasonable suspicion standard. If there were any further material required to demonstrate that, one can see it reflected in the range of preventative legislation which this country has expressly adopted and put before Parliament. The power to make derogating control orders under the Prevention of Terrorism Act 2005 required proof of past terrorism-related activity to a standard of probability. The successor to control orders brought in 2011, the Terrorism Prevention and Investigation Measures, required a standard of reasonable belief. So we say there's no substance in the preventative argument. As to the second, more specific argument and the urging of implementation of the Financial Action Task Force recommendations, you can pick up the resolution itself in the annex to our note of last week, and it's paragraph 7 on page 10 of that note.
Thank you.
And the wording is, strongly urges all member states to implement the comprehensive international standards embodied in the Financial Action Task Force's 40 recommendations on money laundering and the Financial Action Task Force 9 special recommendations on terrorist financing. And the 9 special recommendations contain a recommendation 3. I don't know whether you have the document that my learned friend handed up this morning. It's on page 2. And recommendation 3 is headed freezing and confiscating terrorist assets. Now, we have 4 points as saying a combination of that resolution and this special recommendation do not go as far as demonstrating the necessity of adopting a reasonable suspicion test. The first is that reference was made to the task force recommendations in Ahmed, as we've seen in Lord Hope's speech at 59 and Lord Rogers' speech at 173. Reference was also made to Resolution 1617 of 2005 by Lord Phillips at 139, but that did not lead to any conclusion that reasonable suspicion was required. Secondly, Special Recommendation 3 here says nothing about the standard of proof, and it appears instead to be focusing on domestic measures rather than the question of proposals to the 1267 committee. Thirdly, and because of that, the Secretary of State is driven to go not just to the special recommendations, which are referred to in the resolution, but the interpretive notes, which aren't. And we get those on page 7 of this document, where we do have the tests of both reasonable suspicion and reasonable belief contemplated. But we have my third and fourth points in resisting this argument are, firstly, it's too much of a stretch when searching for respect for the principle of legality and considering what a resolution actually requires to have to trawl through interpretive notes not referred to in that resolution. But fourthly, and perhaps more substantively, even if one goes to those interpretive notes, they don't show application of a standard as low as reasonable suspicion to be required.
How does this work? Because the question you're asking yourself, to whatever legal standard, is what is the prospect that in the future funds or assets, if not frozen, may be used to finance terrorist activity? Now, you can't be satisfied realistically, but beyond reasonable doubt, or even on a balance of probabilities, that if somebody has assets, they will use them to fund terrorist activities. There can't be many such people who say, unless you stop me, this is what I intend to do. So, I mean, there are obviously degrees of mental state implied by the word suspicion, but some such concept surely has got to underlie a situation when you are seeking to forestall something that you cannot be sure is happening, will happen, but which there is a sufficient risk will happen. How do you apply your standard of proof test to a hypothetical future event?
The test for designation has someone met the criteria?
Yes.
The test for whether someone has met the criteria for practical purposes, and by reference to the resolution, is are they associated with Al-Qaeda?
Yes.
1617 of 2005 then gives a series of examples of acts which will indicate association with Al-Qaeda. And so you apply, we say, in determining whether someone meets the criteria, a standard of proof to allegations going to those examples of specific conduct.
Of association.
For association, yes.
I mean, the trouble is the test of association described there is quite extraordinarily broad, and the purpose of the freezing order is specifically to stop funds being used to finance terrorist activity. If there is is there really much of a difference if you form the view that somebody may well support Al-Qaeda financially in the future? Is it something that, can you really disentangle the association and the likelihood of supporting it financially?
Well, you have to some extent, because without the association being made out, there's no basis for someone being included on the list at all.
I mean, there's no other consequence of inclusion on the list other than an asset freeze, is there?
The travel ban, but...
A travel ban,
Yeah.
quite right. Yeah.
So the Secretary of State has got a whole lot of bits and pieces of intelligence in front of him. And he can obviously, to a limited extent, assess their weight and credibility. But can he do much more? Can he ever say, without these bits and pieces of intelligence being tested as we would test something in a court of law, that he's satisfied on the balance of probabilities? Is it unrealistic to apply your test to this sort of inquiry?
My test isn't balance of probabilities, and my objection here is not that Parliament could not have provided for reasonable suspicion being the test. My objection here is that to leave in the hands of the executive the adoption of a test as low as reasonable suspicion runs counter to the principle of legality and cannot be characterised as a proportionate response to the resolutions in circumstances where the resolutions do not say you must apply a standard of reasonable suspicion. And back to the example that my Lord Mance gave in his reasoning in Ahmed, in some other context, United Nations resolutions had specified the standard. And if, subject to the point about broader legality, if these resolutions had said in terms, states deciding whether or not to agree a listing must apply a standard of reasonable suspicion, then that would meet my objection. Because it would be said, quite properly, well, in adopting a test of reasonable suspicion, we were acting in a way that was necessary and proportionate in response to the United Nations resolutions, because that's what they told us to do. But in circumstances where the, where the field was open as to the standard of proof to apply, the same vice identified and animating the judgments in Ahmed is present here.
And so, what is the criterion that, in the light of those absences, the Secretary of State should have applied?
Well, on the authority of Ahmed, the range of views as to what was necessary embraced either reasonable belief, per Lord Phillips, up to proof on balance of probabilities.
Do you say that either of those would be acceptable, but that both of them are more stringent?
To meet this argument, yes. I mean, my fundamental objection is the prior one as to legality. But if it's simply a question of what's proportionate, what's a necessary and proportionate response to these resolutions, then either would be sufficient.
Right. You haven't got very long.
I haven't got very long, my Lord, and I think I'll go, if I may, to the standard of review ground. I don't want to cut myself short on this, and Mr. Swift has very helpfully indicated he has no objection, subject to the court's views, to me cutting into my reply time.
As I said, provided it doesn't, nothing takes Mr. Swift.
No, it won't, my Lord, and I hope I won't need too much of that time.
Thank you, Mr.
Perhaps ironically, given that, it's my respectful submission that this ground of appeal is the clearest and strongest in my favour.
That's why you only need 5 minutes.
Well, I hope so. Try and keep it to that, my Lord.
Yeah, thank
you. It's certainly the least far-reaching and the least profound in terms of its implications, and the one which involves the least departure from exercises that the courts engaged in scrutinising the legality of executive conduct in this very difficult and particular context involves.
Right here.
Because the merits review of the kind we contend for is appropriate here is exactly the kind of merits review that the Court of Appeal in Ahmed itself identified as being available. And it is exactly the kind of merits review which the Court of Appeal in MB, in the context of control orders applying principles of judicial review, held to be appropriate.
So what are we assessing the merits of?
Well, that's the question, my Lord. And I've noted your Lordship's observations in other cases as to what merits review means and what it can be taken to mean. Now, our primary case is it's to be taken to mean what the Court of Appeal in Ahmed said it meant, namely a review by the court, reaching its own view of the factual allegations relied upon against the appellant.
But by whom? By the United Kingdom?
In this context, by the United Kingdom.
So you
Because
want a merits review of the non-torture based
Exactly.
reasons?
Exactly.
Yes, I see.
So one assumes that if the back to the exercise we were discussing earlier, the hold is placed upon a listing, and a decision is taken by the United Kingdom that it has to reach its own decision on whether the information in its possession shows the appellant to meet the criteria for listing. If it does, then consent will be given. One assumes if the conclusion had been the opposite way, consent would not have been given.
Okay.
And that is the exercise that we say is appropriate by way of merits review here. And it involves none of the complications about trespassing on the international terrain that some of the other grounds do. And the Court of Appeal essentially held that it would embrace a decision not only upon whether the factual allegations were made out, but whether the criteria for designation were met. Now, even if that is wrong as a primary case, but we say given that the Court of Appeals endorsed it in this very context, it's quite a promising starting point. Even if that were wrong in terms of the standard of review required, we say we must be entitled to a more intense and exacting scrutiny than has occurred to date, which must embrace at least the first stage of that exercise, namely a merits review of the factual allegations. And for that purpose, we say it's clear that the Court of Appeal applied only a rationality approach, as had the Divisional Court, and it's equally clear in the light of Pham and Kennedy that that's not appropriate, given the interference with rights affected. Now, the Court of Appeal dealt with this issue at paragraphs 41 to 42 of its judgment, and it accepted that judicial review was, in exceptional cases, capable of providing for a merits or proportionality-based review. But it rejected our arguments that that should occur in this case on three bases. First, it held that no question of precedent fact arose. Secondly, it held that no question of proportionality arose because the case fell outside the territory of the Convention. And thirdly, it held that the Foreign Secretary was not exercising any form of discretionary judgment in his approach. Now
That's all part of proportionality, isn't it?
Yes.
Had there been a discretionary judgment to be
Exactly.
effected, so I think it's not a separate point.
Well,
it's a sub-point within two.
Well, one is no question of precedent fact.
Yes.
Two is no question of proportionality because no European Convention rights are engaged. And three is no question of proportionality because no discretionary judgment.
Yes.
So there are 3 points, but my Lord's right, that there are two concepts that are being rejected, merits review and proportionality review. And now we respectfully submit that each of those 3 points was flawed. As to the first question, that of precedent fact, we say it must have been a precondition of any lawful decision to consent to listing that the Foreign Secretary conclude that listing criteria were met. That was the very question that the ministerial submission put before the Foreign Secretary in 2005 raised, and it was acknowledged that a positive answer to it was required before there could be agreement to listing. And that's paragraph 7 of the ministerial submission at Appendix 2, page 809, already seen. And satisfaction of the criteria, we say, manifestly involved questions of fact. Because paragraph 4 of Resolution 1617, with its listing of categories of conduct capable of demonstrating association, did exactly that. Now, Lord Justice Laws concluded at paragraph 42, it seems, that no question of precedent fact arose because of his earlier conclusion, referring to ground 3, his earlier conclusion the standard of proof and that the applicable standard was reasonable suspicion. Well, we respectfully submit that that involves a non sequitur. The fact that a particular standard of proof has to be applied does not prevent a question being one of fact. It merely dictates what will be needed in order to satisfy it. So even on his lordship's own explanation of the reasoning, we respectfully submit it doesn't work. As to the second matter and the issue of proportionality under the Convention, as we pointed out in our printed case at paragraph 88, the case did in fact include complaints under the European Convention. But in any event, and this is a complete answer to the point, we say the observations of this court in Pham and Kennedy, both of which, of course, post-dated the Court of Appeal's consideration of the matter, illustrate that proportionality can arise even in a conventional common law claim for judicial review. And the critical touchstones in determining whether they will arise will be significance of the right in issue, back to my Lord Sumption at 107 in, I think, Pham, significance of the right in issue, degree of interference with it, and extent of the court's competence to resolve the issues before it. So that's the second matter. Proportionality was in play for two reasons. And thirdly, the Secretary of State was exercising a discretion on the structure of the resolutions, even if persuaded on his own information that an individual meets the criteria for listing by the 1267 committee. The resolutions impose upon the Secretary of State no obligation to consent to a proposal for listing. And this is a point we address in more detail at paragraph 93 of our printed case, but it's demonstrated by the fact that a range of individuals against whom coercive measures based upon involvement in international terrorism have been imposed in this jurisdiction are not proposed by the United Kingdom for listing. And it can't be said that the United Kingdom would somehow be in breach of an overarching obligation to freeze the assets of international terrorists by not agreeing to UN-level listing because of the range of domestic measures available, whether by way of control order or otherwise. So this was discretionary territory. The Secretary of State was able to respond to the proposal by saying no to listing but freezing domestically. And the Secretary of State owed no obligation, even once criteria were on his evidence satisfied, to consent to listing. Now, the answer to this ground of challenge, and the respondent very fairly acknowledges that, on one view at least, the legal landscape may be said to have changed since the Court of Appeal's consideration of this issue as a result of Kennedy and Pham. The respondent contends that the challenge nevertheless fails for two reasons. Firstly, it is said that the divisional court did conduct an appropriately intense level of review of the kind contemplated in Pham and Kennedy, and did not confine itself to a Wednesbury rationality challenge. And secondly, that deference was due to the executive in matters of foreign policy and national security. And the appellant admits that neither answer is close to being sufficient.
Is that you're overrunning now by...
I beg your pardon?
You're overrunning now by...
I know I am, my lord, yes.
So I think you better wind up fairly speedily.
I will, my lord. Can I just give
Unless you're proposing to take out your 40 minutes now. Is that what you're proposing?
well, I'm certainly proposing that by whatever margin I overrun now comes off my 40 minutes.
Right, well, if you're both happy with that, it's better to do it now than
I'd rather, my
40
lord,
minutes.
if I may.
Fine. Okay.
Um,
Very well.
so
That's fine.
the two answers identified by the Secretary of State, the Divisional Court did the Kennedy and Pham job anyway, and this is foreign policy, national security, sensitive territory as well, so the Pham-Kennedy approach, even if not applied to date, wouldn't be appropriate. Neither answer, we say, is sustainable. As to the first, the Divisional Court, it is, we say, manifestly clear from its judgment that it exercised a conventional rationality review. And that was the approach endorsed by the Court of Appeal. And that, we say, means the appeal has to succeed on this ground, at least. And the only remaining question concerns the terms of remission to the Divisional Court. But to make good the point about the approach the Divisional Court took, I'd like to direct the Court, if I may, to paragraphs 47 to 59 of the judgment itself. This is in the core volume beginning at page 340, MS 340, page 151. And you see from paragraphs 47 through to 59, under the heading Standard of Review, the argument set out, with the competing arguments summarised at paragraph 47, and the Court's acceptance then at paragraph 56 of the Secretary of State's position. The test of rationality is the Wednesbury test. Now, were there any doubt as to what test was being applied, it's then removed by the heading we get to paragraphs 72 to 84 in the judgment, where the Court rejected what was, as a result of the earlier finding, only a rationality challenge. Uses the term, paragraph 80, rationally concluded. And that's reflected in the language used thereafter at 83. We're not persuaded that it was not open to the Foreign Secretary to accept. Paragraph 84, it does not follow the view taken in 2005 was irrational. And then the Court of Appeal agreed with that approach and found in favour of a conventional rationality test at paragraphs 36 and 43 of its judgment. And there's no question of the Divisional Court doing anything close to what would be a conventional fact-sensitive review of the merits of the kind that, as we'll see in a moment, the Court does adopt in the context of applying judicial review principles to the testing of control orders.
So this is in 2015 or 2016, undertaking a close review of a decision made in 2005.
Yes, of the allegations.
Yes.
The core factual allegations.
With all the material available then.
With all the material available then. And sorry, my Lord. Yes.
Yeah, so and what does it lead to if you succeed?
It leads to a remission to the Divisional Court, the Administrative Court.
I've got that. That's the court to do it. But if you succeed before the Divisional Court, what do you get then?
We get a declaration as to the unlawfulness of the decision by the Secretary of State to consent to the listing.
And then?
And then that will properly inform the Secretary of State's approach to whether or not to support delisting.
Well,
it won't.
He appears to be listed now on a completely different basis.
He does, my Lord, but it's...
So you would have to start all over again trying to challenge the current basis, wouldn't you?
Yeah, we'd have to challenge both, I think, my Lord.
Realistically, but...
It wouldn't matter what the old basis was as far as the future was concerned. How is this actually going to get the freeze lifted?
Nothing will get the freeze lifted until the 1267 committee decides that he should come off the list.
General Court says that European law
or the General Court
trumps.
says European law and does something that it hasn't yet done to date. Yeah. What the General Court has done to date in the Caddy round of litigation has been to annul regulations but suspend the effect of that annulment until further consideration is given.
I mean, one understands your client's position, and he obviously has an understandable concern or position arising out of his personal circumstances, but on the other hand, at the end of the day, there's a long route to go. If let us suppose that you can't successfully challenge the current listing, because it's done independently of any of the problematic aspects. Suppose that's the case. I mean, does this litigation have practical reality? Would there be damages claims, or what is the position then?
Well, its practical reality is to force a reconsideration at the moment of the United Kingdom's decision not to support delisting. And it appears to be conceded, because of the section of my own friend's case dealing with remedy, that if we're right as to declarations of unlawfulness on the part of the United Kingdom, that would manifestly be relevant to inform the United Kingdom's approach to delisting.
Well, not anymore. I mean, the United Kingdom strenuously, according to the Statement of Facts, attempted to obtain delisting for a number of years,
yes,
until the new material came forward, and the United Kingdom was persuaded by the Ombudsperson's report, recommendations, that it should drop that. So, I mean, it's a completely different challenge. Is it afoot anywhere at the moment?
Yes, there's been a I think notice of a claim given to challenge the decision no longer to support delisting. And
why were you busy on a 2005 decision when the one who really ought to be challenging is something quite different?
because, my Lord, but for what we contend to be the unlawful conduct of the Secretary of State, there would have been no asset freeze.
Yeah.
I understand that, but you're not suggesting you're claiming damages for 10 years of being frozen, as I understand it.
No, my Lord, but it
So
doesn't.
your only objective is to get yourself delisted, and the only way you can do that is by challenging the recent decision.
We say that if this court were to hold that the United Kingdom's decision to support listing in 2005 was unlawful, that would be a mandatorily relevant factor for the Secretary of State to have regard to in deciding how to approach delisting now.
Why?
And
Why? It's all water under the bridge, factually.
I suppose
Well,
the standard of review, or the test which he should be applying, you would hope, be established in your favour.
the test he would be applying will be established in our favour. And with respect, my Lord, it's not water under the bridge in the sense that it's not had any consequence. The consequence, we say,
Water under the bridge has consequences, it's just there are consequences in the past.
and the adjectives applied to that, flowing of the water under the bridge, devastating, oppressive, and so forth.
Well, yes.
Are
I mean, you know, one could understand if he was seeking some sort of remedy for that, but he's not.
Well, we need this appeal to succeed to decide the correct standard of review, and that is relevant both to standard of review of the allegations of past conduct relied upon in relation to the 2005 decision, and it will also, of course, necessarily be relevant to standard of review of the 2011 to 2013 allegations, which now form the basis of the Secretary of State's position. Whether this will get anywhere is a speculative exercise. What is not, we say, a speculative exercise is what standard of review, as at 2013, when the Divisional Court considered this, the appellant was entitled to. And as at 2013, even though those statements had all, on the Secretary of State's case, been made, the Secretary of State was still pursuing delisting at that point. There had never been any attempt to interview the appellant in relation to any of the statements now attributed to him, and the position of the United Kingdom was still that delisting was appropriate. 2012 was the Divisional Court.
Yep.
So that leaves the question. First question on standard of review is, what did the Divisional Court do? And the answer to that is conventional rationality. Second question, and final question on standard of review, is, does the context make any difference? And is there any mileage in the Secretary of State's invocation of the sensitive foreign policy context as he would have it? and counter-terrorism context. And we say, of course, as a matter of generality, considerations of that nature can impact upon standard of review, Lord Carlisle's case being one example of that. But in the Lord Carlisle litigation, there was no dispute about underlying fact. On the contrary, we have, by way of example here, both in the Ahmed case in the Court of Appeal and the Court of Appeal in MB, making it clear that precisely the kind of exercise that we say is appropriate can be performed, notwithstanding, in Ahmed, the precise counter-terrorism international relations context in issue here, namely implementation and response to United Nations resolutions and designations before the 1267 Committee. My Lord Justice Wilson, Lord Justice Wilson as he then was, will remember that case, and Lord Clark, Lord Justice Wilson as he then was, and Lord Justice Sedley, all identifying the viability of a merits-based review in this specific context. Likewise, MB in the Court of Appeal. So the only two bases upon which the standard of review, in fact, adopted by the Divisional Court are defended, cannot, we respectfully submit, be sustained. If I could just close by giving the paragraph references to Ahmed in the Court of Appeal. Lord Clark, Sir Anthony Clark as he then was, paragraphs 113 to 121, especially paragraphs 119 to 121. This is MS 1268.
Yep.
Volume 1, Tab 2. Lord Justice Sedley at paragraph 147.
Thank you.
And Lord Justice Wilson at paragraph 157.
Thank you.
And then MB in the Court of Appeal, which is Volume 3, Tab 13, MS 1943, and it's Lord Phillips's judgment at
Page. Or paragraph.
paragraphs 9, 12, and in particular 60.
9, 12,
60, he characterises the existence or otherwise of reasonable suspicion as an objective question of fact.
Well.
So the overall position, my lords, is we respectfully say quite clear on this ground. The Divisional Court applied a standard of review of conventional rationality. The powers of the court are undoubtedly sufficiently wide to allow for one of the two forms of merits review we contend would be appropriate. And thirdly, on each occasion in recent times that Parliament and the courts have considered analogous powers, the approach has been to provide for judicial review embracing a merits review. And we get that from the Prevention of Terrorism Act, merits review of reasonable suspicion, the TPIM Act, merits review of reasonable belief, and we get it also from the Counter-Terrorism Act in relation to financial sanctions. The case isn't in the bundle, but it's perhaps worth emphasising at the end of my submissions that Bank Mellat in this court involved consideration of a context where Mr. Justice Mitting had made specific findings of fact as to allegations of past conduct in a context identified by my Lord Sumption as just as difficult and sensitive as the counter-terrorism context, the nuclear proliferation context. And then after that exercise of fact-finding, conducted an intense proportionality review. So, my lords, consistent with the approach in Bank Mellat, but most recently in Pham and Kennedy, we respectfully submit that there can be only one outcome to the question of ground 4, and that is that we win. As to whether or not remission, embracing both those past facts, and if the Secretary of State, as one assumes he will, chooses to rely upon the new alleged facts, as to the outcome of that exercise, that will be a matter for the Administrative Court.
Understand.
But if we're successful in knocking out both 2005 and 2013, then we would say we will be in very strong territory to require the Secretary of State to seek our delisting and therefore give rise to at least a prospect of the listing and the freezing regime ending. My Lord, I think I'm down to 19 minutes for my reply, which I'm entirely content with, and I'm very grateful for the patience the board has shown me in extending me that extra time.
Thank you very much, Mr. Ottey. Mr. Squires. Thank you. Mr. Swift.
My Lord, if I may, I will take the issues in the same order that Mr. Ottey took them. But before I go to the first of them, could I just take you briefly to the documents going directly to the decision of the Secretary of State? It's common ground, obviously, that this is a challenge to the Foreign Secretary's decision of September 2005 to release the hold that he had placed. It's also common ground that, as it was in the Court of Appeal, that the Foreign Secretary's decision was not itself taken on the basis of torture-obtained evidence. But the documents that the Foreign Secretary had for this purpose, to the extent that they were not the subject of a public interest immunity certificate, are in part 2 of the appendix. My Lord, there are 2 of them. The first is the ministerial submission. It's MS page 997, ordinary page 808.
Yes, we looked at that, I think.
And the document runs for 4 pages or so. You'll see various redactions that were made with the permission of Mr. Justice Silva. Taking the thing quickly, the issue is identified as how to respond to a proposal to add 20 individuals, including 4 UK residents. Then under the argument, it says on 29th of March, a state, as we now know, Egypt, proposed the 1267 committee add 20 individuals to its consolidated list. Then flag A was an attached document. Designated individuals are subject to an international assets freeze, travel ban and arms embargo. UK placed a hold on the proposal. Last line of that paragraph, we have informed, again, proposing state bilaterally that we were considering their proposal and requested more information. The next paragraph deals with criteria. Paragraph 7, Egypt alleges all 20 individuals are members of the UN-designated terror group EIJ, have provided specific information on each individual of varying quality. To agree the proposal, the UK must judge they meet the designation criteria. Although the designation criteria remain the same whether the individual is in the UK or overseas, in practice, we have to concentrate our assessment on UK residents. For the UK residents, we are likely to have more relevant information, be in the best position to judge their case reasonably, and will be responsible for implementing the measures against the individual and responding to any legal challenges. Then paragraph 8 refers to the security service assessment, and you see the reference there in the first line to flag B, which I'll take you to in a moment. So officials judged 2 of the 4 individuals resident in the UK, and a further 5 meet the criteria for designation. And then the first one there, Al-Sibai, is Mr. Youssef. Then flag B is at MS page 988.
988.
Yes, regular page 799.
Thank you.
And what you have here is a redacted version of the information provided by the security service. It's been retyped rather than it's blanked out.
Thank you.
So again, this is what survived the PII process. Can I ask you to note this? Firstly, you see that it's divided between information that could be released to the 1267 committee, which is the small paragraph in the middle of the page, and the remainder of the document which should not be so released.
Yes, I see.
In fact, the Foreign Secretary provided no information to the 1267 committee, but you see there this distinction right at the outset.
Yes.
Then the security service assessment towards the bottom of the page, the last 2 paragraphs, following his release, this was following a period in custody pending a deportation that did not take place.
We see that for the previous paragraph.
Sabai has strong historical links to EIJ during the mid and late 1990s. The potential remains for him to re-engage with the EIJ, and then reference there to a footnote to the document. So obviously there was further information before the Foreign Secretary, but that is the information that he had. In terms of the evidence available to the court as to the decision taken by the Foreign Secretary, for your note, that is in Mr. Morrison's statement between paragraphs 19 and 31, and those paragraphs start in Appendix Part 2 at MS 885.
What's the other page number, please?
696.
Thank you.
The points that Mr. Morrison makes there include the following. Firstly, that the Secretary of State took into account the information in the submission.
Sorry,
of the
what
memo.
page are we looking at?
I wasn't asking you to, my lord, but as we're there,
I'm sorry, if in that case, don't worry.
it's statement. It's 696 in the middle of the page, and 885 is the MS number. It's starting with paragraph 19 of Mr. Morrison's statement.
The claimant's listing, yep.
It's the run of paragraphs from 19 to 31.
Thank you.
And by way of summary, Mr. Morrison explains the Secretary of State took into account the information in the submission and the memo. The information that the Secretary of State relied on did not include the information put forward by Egypt. The information did, contends Mr. Morrison, provide sufficient information for the conclusion that Mr. Youssef met the criteria for designation. Mr. Morrison also makes the point that I've already mentioned, that the Foreign Secretary did not provide this information to any person or state on the 1267 committee. Pausing there a moment, Mr. Otti has contended that the Foreign Secretary encouraged the committee to designate Mr. Youssef. That is a contention that I contest. It is true that the Foreign Secretary released his hold on the proposed designation. The hold itself was not an exceptional step. As has been explained to you, it was open to any member of the committee faced with a designation proposal to place a hold on it simply to give itself more time to consider the position. Given that this was a proposal that included a proposal for UK residents, entirely natural that in those circumstances the Foreign Secretary would wish to consider the position when another state was making the proposal. Save for releasing the hold, the Secretary of State took no positive action in relation to the proposal. So yes, he agreed to it. Absent his consent, the matter could not have been decided by the 1267 committee, but would instead, at that time, have been referred to the Security Council for decision. And clearly at that stage, the Foreign Secretary would have had, the decision would have been taken in accordance with the Security Council's normal voting rules, so a majority and no veto by any of the 5 core states. In those circumstances, the Foreign Secretary would have cast a vote or not as on behalf of the United Kingdom. That's Mr. Morrison's evidence in summary. There is further evidence that is relevant in a statement of Mr. Scott. It's his third witness statement. The MS page reference number, the statement starts at MS 971. And the material part of it,
Page number, please.
yes, sorry, my lord, yes. It is 782.
Thank you.
Can't win. You give one that set and one judge asks you for the other set. And
Yes,
give the other set.
I was thinking of splitting the difference and confounding everything. My lord,
Yes,
paragraphs 5 to 6 of that statement, I
Thank
don't
you.
invite you to go to it, but what Mr. Scott addresses in that statement is the question of what would the standard of proof, or would a different approach to the standard of proof have made any difference to the outcome of the Foreign Secretary's decision based on the information that he had?
Yes.
He explains there 2 things. Firstly, that reasonable suspicion was the standard that the Foreign Secretary applied, because that remains the standard that the Foreign Secretary applied as at the date of Mr. Scott's statement. And secondly, that Mr. Scott, having reviewed the evidence, did not consider that a different standard of proof, for example, reasonable belief rather than reasonable suspicion, or for that matter, balance of probabilities, would have made a difference to the outcome that the Foreign Secretary
Is that the
would have
correct
reached.
approach in public law? Or do you have to show that the decision would inevitably have been the same? Yeah.
There are quite a lot of cases where the courts have expressed great reservation about refusing to accede to judicial review applications on the ground that the result would have been the same, not that.
Yes, and
The
there are
famous
some...
observation of, I think, Sir Robert McGarry about that.
Yes, well, that was in the particular context of the absence of a hearing where fairness required a hearing.
Well, whatever
but-
it was,
well,
yes,
the,
you're quite
the
right.
only...
It was.
Don't get me wrong. I'm not putting the no difference argument at the front of my submissions. I simply draw it to your attention. So far, you have not been taken to the evidence relevant to the decision, and this is that
But
evidence.
it is, I mean, I wouldn't be put off too rapidly.
I'm not
Because these,
throwing it out.
I
but
mean,
it's
one
not
of the
my
things
first
I'm going to ask you about at some point is how discretion comes into this, because judicial review is a discretionary remedy.
Yes.
And when we're being asked to review a decision made 10 years ago, which admittedly is not actually the decision which is going to have any effect on the applicant's freedom, then I think we're allowed to take into account a number of things. One of them I would have thought was what actually the evidence would have shown if a different test had been applied. And
Well,
I certainly know
that
nothing
is-
which excludes that from the discretionary exercise.
That is precisely why I mentioned the point now, to come back to it later in relation to remedies. And of course, in this case, in addition to that Mr. Scott says, obviously by reference to all the information that was before the Secretary of State, you also, by reference to the information that survived the PII process, have the views expressed by the Divisional Court. And I'll say that they will also be significant when it comes to the question of relief
Context, yes.
at the end of my submissions. But, my Lord, that is a brief tour of the relevant evidence. May I turn now to deal with the first ground of appeal, which is the ground relating to the proposal
Yes.
based on evidence that either was or may have been obtained by torture.
Yes.
As I understand Mr. Youssef's case, it's this, that because the Foreign Secretary was aware that the proposing state's information was or may have been obtained by torture, his consent to Mr. Youssef's designation, it's the first way in which the case is put, amounted to a form of endorsement of the reasons for the decision of the 1267 Committee, and for that reason was unlawful. The first way in which the case is put. The second way is by reference to the nature of the obligations arising from the prohibition against torture. If I can deal with the first way in which this point is put, there are two submissions that I make in response to it. The first submission is that I say you should adopt significant caution before embarking on adjudication as to what the requirements were on members of the 1267 Committee pursuant to the Security Council resolutions in terms of stating reasons for their decision or even formulating reasons for their decision if those reasons were not publicly stated. My submission is that is not a matter on which this court should seek to rule. Necessarily, if you did determine it, you would be determining a matter of international law.
Are we really determining that, or are we looking at it through the eyes of the Secretary of State as he was sitting there wondering whether to vote or not?
Well, not in the way the case is put. No,
Well-
you're not doing that at all. Because the way in which the case is put, as I understand it, is that the Secretary of State was endorsing a torture-based decision.
It must be through his eyes, mustn't it? Because that's all he had to go on.
Well, if you look at it simply through the eyes of the Secretary of State, he wasn't endorsing a torture-based deciation.
Well, he was endorsing, what's said is that he was endorsing a decision which he appreciated, or ought to have appreciated if he thought about it, appeared to him to be based on, should have appeared to him to be based on torture.
Well, but that leads you straight into the territory of deciding, well, what were the obligations of the members of the committee at that time?
Including the Secretary of State.
Including the Secretary of State, but obligations as between themselves. So what obligation did they have to provide each other with the information they wanted to rely on? What obligation did they have to explain their position? I rely on X, I don't rely on Y. A state might say, actually, I don't rely on any of this evidence, but I see that state Y, whose judgment I trust, is voting yes, and so I vote yes as well. So one could see there could be a whole range of reasons why a state that is a member of the 1267 Committee might decide to accept a proposal for listing.
I think the argument against you has to be based, and it's slightly weakened by the reason the Secretary of State voted in this case, but that in the absence of reasons to the contrary being expressed, you assume that the decision of the other members is based on the evidence put before the committee. That's got to be the argument. I
Well,
think.
that's the argument, my lord. That requires you to decide what the position was, what the rules were for the 1267 committee, and those rules were established by the Security Council resolutions and by the guidelines published by the committee itself from time to time. So you are asked right at the outset to embark on the process of construing those guidelines and concluding, for example, that one should conclude that in the absence of a statement of reasons, there were reasons for the decision beyond the bare conclusion that the person proposed met the criteria, and that those reasons were to be taken to be the reasons of the proposing state. Now, so far as your conclusion might affect the Foreign Secretary, well, one might say, well, that's just run of the mill. But your conclusions would inevitably also be taken to establish the obligations on all other states acting as members of the 1267 committee. And so you would be declaring the obligations, for example, on the French, the American...
And on that basis, it could be argued we can never decide an international law point because it might affect other people.
This isn't a question of might, my lord.
Well, no,
This is a question of will.
it doesn't affect them because they're not parties. It affects the Foreign Secretary because he's a party. The logical conclusion would be, as a matter of law, that the others may well be that it would affect the others, but they're not parties. They're not bound by it in any way.
But, well, in my submission, this isn't a situation such as the
It's
situation...
not a point wholly different from one we've been recently considering about act of state and state immunity. But,
Yes,
if you're not a party to the proceedings, you're not bound by the decision. And
Well-
the fact that we may affect somebody, logically may lead to the same conclusion if they'd been parties and had come up with no different arguments, doesn't mean they're bound by it.
No, but my lord, historically, there has been a practice of restraint on the part of the English courts when it comes to determining matters of international law. This case is far distant from the situation before this court in Ahmed, when what the court needed to do was to look at a resolution passed by the Security Council and based on that decide the extent of the powers available under Section 1 of the United Nations Act.
Yes, but it
What
could be
you're-
said that here, all we're being asked to do is to look at how it must have appeared, or on the evidence we've got, should have appeared, to the Secretary of State. Nobody else, how it would have appeared to him.
Well-
And all he saw would have seen the other people having before them was the evidence which is said to be tainted.
Well, my lord,
That's the argument.
Yes, if you
I think
approach it
that's
on that
well to be
basis,
put.
how it must have appeared to the Secretary of State, the Foreign Secretary, clearly that would not require you to reach any conclusions as to, for example, whether the committee had formulated reasons for its decision,
Quite.
or whether the reasons of the proposing state were taken to be the reasons of the committee. If
Can
you
I just-
approach it on that basis, then you do not fall into the difficulties that I say otherwise exist of actually declaring what the obligations of the members of the committee are as between themselves. However, if all you do is approach the matter from the perspective of how it must have appeared to the Secretary of State, then the reality of the position is very different. It doesn't assist Mr. Youssef either, because my second submission is that in any event, the contention that what the Secretary of State did was some form of endorsement of the reasons of the proposing state.
But can I just, before you make that submission,
Sorry, yes.
Understand what the facts are said to be? I'm looking at Mr. Morrison's witness statement.
Yes.
And this tells us that the United Kingdom received the note verbal of the Egyptian government with a statement that the claimant had been convicted for membership of EIJ, and the United Kingdom then received additional information supplied in June 2005. At paragraph 25, it said that the information provided by the designating state in support of the proposal other than the list of names, was not put before the Foreign Secretary. So am I to understand that the Foreign Secretary was not told the content of the Egyptian government's reasons for wishing to designate him, either the original ones or the further reasons supplied in June, but only the name? So does it follow from that he didn't know that the Egyptian government was proposing a listing based on a torture-tainted conviction?
Correct. Officials went out of their way to ensure having...
Though they knew he was not told this.
Exactly.
I see.
Well, paragraph 21 of this statement of Mr. Morrison, 696, the members of the committee, including the UK, did get Interpol's red note.
Yes.
Paragraph 22, Egypt provided to the chairman additional information which was circulated to members of the 1267 committee,
Yes.
including the UK.
Yes.
So we've now got the three documents which Mr. Otti identified.
Yes, but...
So I understand
provided-
that the decision maker wasn't told that.
No, this is a decision taken by the Foreign Secretary rather than by officials on his behalf. The documents that were provided to the United Kingdom's representative in New York. So, my lord, the evidence is Mr. Morrison's evidence is internally consistent in that the Foreign Secretary was not shown the documents provided by
Well,
Egypt.
shouldn't he have been shown them?
Well,
Well, if he wasn't allowed to take torture-tainted evidence into account, presumably the only way of ensuring that he didn't was
to
to
quarantine.
give him only other evidence.
But those who advised him had the evidence.
yes. But,
Yes.
as you've seen from the submission, the reason I took you to the submission at the outset, that did not figure in the submission made to the Secretary of State. And as this court...
So the FCO had the information. They had based their advice, no doubt, on all the information they had. They just didn't mention the information when they advised the Secretary of... or they only mentioned some of it.
Well, I think the suggestion is they didn't even base their advice on that,
No, exactly,
that
yes.
information. They excluded it because they recognised it was improper to be guided by it.
And, my lord...
How does the Carl Toner principle apply in that situation?
Well, good point. The way in which the Court of Appeal has said Carl Toner applies in that situation is that there is no reverse called Carl Toner. So one cannot attribute to the Secretary of State, if he is the decision maker in person, information that is known to members of his department but is not passed on to him.
No, you would say this is the way the system should work.
I'm sorry, my lord.
You would say this is the way
Yes.
the system should work.
Indeed. Because otherwise, the debate before the court would be the Secretary of State was shown the information,
Right.
was then told not to rely on it.
Right. No, I understand that.
So,
So the questions I was putting to you a minute ago were based on a false assumption, it's fair to say. Yes, I see.
so
Yep.
Going back a second ago to
Thank you.
a submission you were making about the position of international law, ought we to look at another case, possibly McLean-Watson and the International Tin Council?
God, no.
Well, I mean, that does establish that it's not the role of domestic courts
Yep.
and that they're to construe or give domestic effect to purely international
yes.
agreements, and it has some relevance, possibly.
Yes.
I mean, there's some pretty clear statements. It also considers Butte's gas.
Yes.
And that sort of
suspect trend-
statements
If we
about-
do, can we limit the number of pages we look at?
Yes, I think that might be a good idea.
It will be no more than the number of pages that Mr. O'Connor can read between now and 10:30 tomorrow morning.
Well, I imagine that's quite a lot of pages.
Yes.
Okay, so coming back to this, the essential point is, your essential point is, the Secretary of State didn't know that there was evidence obtained by torture. His officials intentionally kept it from him perfectly properly and gave their advice based on other evidence.
Yes.
So we don't get, you say, to first base on this because he didn't know what the others were relying on.
Yes.
Right, well, that seems a pretty powerful point.
And, my lord, that is my second submission, is on the evidence, and one simply cannot associate the Foreign Secretary with the reasons that were put forward by the proposing state.
Yeah.
Now, in addition to the point that has just emerged, there are further circumstantial points. Firstly, the Foreign Secretary would not be aware of the reasons why the other members of the 1267 committee agreed to the proposal.
Yeah.
There was, as you have seen, no statement of reasons by the committee. What the committee did at that time, when it took a decision to accept a proposal, was to publish simply the fact that the person was subject to sanctions and to publish various information that served to identify the person. So identifying information only. There was no statement of the reason why the decision had been taken. You may, well, I'll
Just remind me how many members of the Security Council there are. In fact,
9.
certainly in the teens, is it?
Yes, it is.
15, somewhere around there?
I was going to say 20, but I will
Maybe.
check overnight rather than rely on my own
We can
pop
no doubt
quiz.
look up, yeah.
It is 15. I'm told it is 15. Those that behind me that know say it is 15.
Yes, I thought so.
Just by
15,
way of
yeah.
example of that, of the information that was published, again, for your note, in Appendix Part 2, at MS page 780, which is normal page number 965, there is a copy of the Treasury Circular.
I ran out of normal pages at 942.
That's 780 is the, what, is this the penultimate page of an affidavit dated 10th of, statement dated 10th November?
Yes,
Yes, it's 780 on your pages.
So it's not MS8.
It isn't, it's the other way around.
Sorry, is it? Let me
It's not your, don't worry. We start with paragraph 11 on the page, yes?
It's a statement. I think I've given you the wrong reference.
Ah,
It is. Yes, I have.
page?
Let me just. It's regular page number. Oh dear.
What's the MS?
The MS I have is at 780, but as you will appreciate, my
I think,
my
yes.
book didn't have the MS on it.
I think you'll find it, I think you'll probably 592, I think, 592, I think, if it's
Regular 591, I'm told.
591, right, okay.
Regular page number. What you see here, 10th October 2005, this is the circular issued by the Bank of England following the decision. And you will see there the information that's published in relation to Mr. Youssef is number 4 on the next page. It's simply information that would serve to identify him, and that was information of the sort published by the Security Council itself. So no statement of reasons by the committee, and on that basis I say no basis for the contention that the Foreign Secretary could be associated with any statement of reasons by the committee. I accept that in terms of the way in which the committee operates, there have been significant developments since 2005. However,
Well, that's not-
as at September 2005, the relevant documents were, firstly, Resolution 1617, which is Authorities Volume 7, Tab 49, and secondly, the relevant version of the 1267 Committee Procedures, which is the 2003 version that you have at Volume 8, page 67. Now, taking each of those in turn, firstly the Security Council resolution, which is Volume 7, page 49.
Yep. Tab,
It's MS 3277.
yep.
That resolution, at paragraph 1 on MS 3278,
Sorry, can you give me a bundle and tab number?
I'm sorry, my lord, Volume 7, tab 49. Paragraph 1 of the resolution, operative paragraph 1 towards the bottom third of page 3278,
Yep.
repeats the asset freeze and prohibition on provision of resources measures. Then paragraph 2 on the next page identifies what the notion of associated with includes, so
Yep.
a non-exhaustive definition of that there. And then paragraph 4 says, decides that when proposing names for the consolidated list, states shall act in accordance with paragraph 17 of Resolution 1526, and henceforth also shall provide to the committee a statement of the case describing the basis of the proposal, and further encourages states to identify any undertakings and entities owned or controlled directly or indirectly by the proposed subject. And then, skipping over 5, going to 6, decides that the statement of case submitted by the designating state, referred to in 4 above, may be used by the committee in responding to queries from member states whose nationals, residents or entities have been included on the consolidated list, and then decides also that the committee may decide on a case-by-case basis to release information to other parties with the prior consent of the designating state. By designating state, they mean proposing state, for example, for operational reasons or to aid the implementation of the measures. So one sees there the resolution does refer specifically to a requirement on the proposing state to provide information, but there is nothing in the resolution that requires the committee to state reasons for its decision. Although paragraph 6 does say that the information provided by the proposing state may be used by the committee to respond to queries. Firstly, the real point that paragraph 6 is making is a point concerning the confidentiality of information provided to the 1267 committee. And so one sees there that rather than, and this would be the default position, that all information provided to the committee would, as a matter of course, be regarded as confidential to the members of the committee, paragraph 6 indicates that it is possible for that information to be used. But again, one cannot make out from paragraph 6 the notion that the information provided by the designating state is in fact the committee's reasons for taking the decision to add the person's name to the consolidated list.
I suppose one might have a situation where the statement of case having been put forward in committee, people pointed out, look, we don't quite see it like that, and there was discussion and the decision was taken on a different basis. Then the committee under paragraph 6, if it was asked for the statement of case, would have to say, look, I'm sorry, well, they'd have to concoct something different.
Yeah. Or they may simply not provide information.
Or refuse to provide it. Say the statement of case doesn't represent the basis on which... yeah.
My Lord, drawing these matters together, my submission is that as at 2005, there was nothing about the way in which the members of the committee went about their business from which any agreement on the reasons for a decision could be inferred. Actually, before I continue with that, I should also take you to the committee's guidelines. That's in volume 8.
Thank you.
At tab 67.
Yep.
And you can see from the top of the page, these are the guidance as amended by 10th of April 2003.
Yep.
Insofar as relevant, then paragraph 5 at the bottom of page 3460
Yep.
lists of individuals and entities referred to in paragraph 2 of the then effective resolution. B, proposed additions to the list should also include, to the extent possible, a narrative description of the information that forms the basis or justification for taking action. So again, something that reflects what was then put into Resolution 1617, paragraph 4. Thereafter, in my submission, there is nothing in this that makes good the contention that the committee actually stated or formulated reasons for its decision.
Right.
Before I leave the document, could I refer you briefly paragraph 9 on page 3463?
Yes.
Under decision-making,
Yes.
I think Mr. Ottey made the point in his submissions that as at September 2005, there was no 6-month limitation on the duration of a hold. And that is right. What actually happened in that situation would be, well, one sees, firstly, the committee would attempt to establish a consensus. If consensus could not be established, and it would be a matter for the chairman of the committee to decide when that point had been reached, the matter would then be referred to the Security Council itself for its determination in accordance with its usual voting procedures.
Right.
So that's the way in which matters.
So when we've been proceeding, at least I've been proceeding on the assumption that unanimity was required, is that actually the test, or is it consensus? Because consensus doesn't necessarily mean unanimity. There may be a consensus among the committee, notwithstanding that, say, 3 people disagreed.
I think consensus here was used in the sense of unanimity.
It does?
Yes.
Okay.
Yes.
It does, surely it means, well, I mean, as far as the 5 permanent members of the Security Council,
Yes.
they have to assent.
Well, so within the committee, everyone has to agree
Yes.
if the committee is to take a decision.
Where do we find that stated?
Well, my lord, what I can
It's
point...
simply the construction in the United Nations of the word consensus.
Yes, that is what the members of the committee understood the position to be, and that is the basis on which they acted.
Well,
Well, that tends to be supported by paragraph B. If no objection is received, the decision will be deemed adopted. It ends up saying 9B, which seems, I mean, it's not necessarily so, but it looks as if.
But certainly the practice was, both for listing decisions and delisting decisions, that consensus meant unanimous agreement. One of the stumbling blocks the United Kingdom faced during the period it was attempting to secure Mr. Youssef's removal from the list.
Consensus means, here it means everyone consenting.
Yes, exactly.
But this implies that it can be overridden by a decision of the Security
Oh, yes.
Council.
Well,
Yes.
not overridden. If a proposal is either...
Only if consensus cannot be reached.
Yes,
Yes, exactly. If a proposal is accepted by the committee's decision stands,
Yes.
subject, of course, to subsequent resolution by the Security Council, because in the end, this is just a committee of the Security Council. If the committee cannot agree, then the matter goes to the Security Council, and on that basis, the decision would be taken by reference to the usual qualified majority rules that apply to the Security Council. So a majority and no permanent member objecting.
Yes, so again, I mean, the UK would have a veto on that
Yes, but one can see,
as a permanent member of the Security
or
Council.
rather would have to vote in favour of it.
Have to vote in favour, yeah.
But in those circumstances, the Security Council could impose sanctions so long as every permanent member voted in favour, if a minority of other members disagree.
UK to abstain, it would still go through them, wouldn't it?
No, I don't think so, no.
I will
Abstention
ask
is a
for
veto.
instructions
Yeah,
on that.
that's the whole point, yeah. You can be unaggressive, a passive veto.
But coming back to my submission, it is clear, I say, that at this time, the members of the committee had no truly collective approach to the decisions on listing proposals. Each would assess the proposal for itself. Again, I draw your attention back to the way in which the Foreign Secretary looked at this decision in September 2005. The point was made that his decision should not be taken on the basis of the proposing state's information.
Understand.
The committee members did not explain or reveal to each other what their reasons were for their views, nor were they under any obligation to provide information that each themselves had considered when deciding what to do on the proposal.
Is there actually a meeting of this committee? Do they all gather in one place?
Yes, although, as you
Well, they
will
can
see
take
from
a
documents,
written procedure.
There can be a written procedure as well, depending on...
9B permits written.
But in this case, was there a meeting?
I will check. I believe that there was.
And is the meeting purely formal? Hands up, whoever disagrees.
If you want to take the longer adjournment to find out this information.
Yes, I will,
welcome
whether
to
it's
do
a
so.
dad's army situation where...
Which you can check as well. Abstention or absence from the vote by a permanent member does not prevent a draft resolution from being adopted. So there seems to be a difference, but no doubt Wikipedia is inaccurate.
I will take instructions.
Well, it must be in the charter.
Yes, I think it probably is.
Very well. Well, perhaps this is a convenient moment. We'll resume again then at 10:30 tomorrow morning. Thank you very much indeed. Court's now adjourned.